Welcome! Today we're diving into a really powerful tool in Ontario's civil litigation process. It's called the motion to compel, and, well, it's basically what happens when the legal system needs to give someone a very firm nudge to play by the rules.
So let's just jump right in with a situation that honestly happens all the time. Imagine you're in the discovery phase of a lawsuit. This is supposed to be all about transparency, right? But the other side, they're refusing to answer key questions. They won't hand over critical documents. Your case is just stuck. What on earth are you supposed to do?
Well, don't worry, the rules of civil procedure have a very specific game plan for this exact problem. First, we're going to talk about the standoff itself. Then, the tool you use to solve it. After that, the super important chart you have to create. Then we'll cover the tight deadlines you have to meet. And finally, my favorite part, the serious consequences for not playing along.
Okay, so first up, the discovery standoff. We need to be really clear about what this is. This isn't just someone being a little difficult. It's a real breakdown in the fundamental machinery of justice. You see, the whole pretrial process is built on this idea of discovery. It means both sides have to show their hands so there are no big surprises at trial. It's all about fairness. So when one side decides to hide the ball, they're not just causing a delay, they're actually undermining the entire system, and that's the standoff the rules are designed to break.
So, how do you break that standoff? You can't just call up the judge and complain. Nope, you have to use a formal and very powerful legal instrument.
And here it is, the motion to compel. This is your solution. It's you, as the moving party, officially asking the court to step in and order the other side to do what they're supposed to do. It completely changes the game. It's no longer just a request from you, it becomes a direct command from a judge.
Now, here's a crucial point. When you go to the court with this request, you can't just write up a long email listing all your complaints. The court has a very specific format it wants you to use, and it's designed to make everything crystal clear and super efficient. And trust me, the rules are not messing around. Rule 37.10, subsection 10, uses the word shall. In law, that's a magic word. It means this chart is not a suggestion. It is absolutely mandatory. If you show up to court for a motion to compel without one, well, it's not going to go well for you. And what's really cool about this slide is it shows you the simple brilliance of Form 37C. This chart just boils the whole argument down for the judge. It's so clean. Column 1, here's the question number from the transcript. Column 2, here's the exact question we asked. Column 3, here's a space for the other side to explain why they're refusing. It's all right there. No fuss.
Okay, let's keep moving, because just using the right form is only half the battle. The rules also put everyone on a very strict, very fast-paced timeline. The clock is ticking.
This whole timeline is laid out right there in Rule 37.10. So, as the one bringing the motion, you have to serve and file your chart at least 7 days before the hearing. Then the other side gets until 4 days before the hearing to fill in their part of the chart and file it. This system is designed so that when the judge walks into that courtroom, they've got both sides of the story neatly organized and they're ready to make a call.
This brings us to the final, and let's be honest, the most critical piece of this whole puzzle. What happens if a party just ignores a court order to give you the information? This is where the rules really show their teeth.
And yeah, look at this. These are not small penalties. We're talking about the ultimate consequences here. Under rules like 30.08 and 34.15, if a plaintiff, the one who started the lawsuit, refuses to comply, a judge can just throw their entire case out. Done. And if it's the defendant who refuses, the court can strike their defense, which usually means they automatically lose. The stakes just could not be higher. And the court has a whole bunch of other tools in its toolkit, drawing from rules like 31.07 and 35.04. They can order the person to come back for questioning again, only this time they have to pay for it themselves. They can say that the very evidence they refuse to share, yeah, they're not allowed to use it at trial. And almost every single time, the judge will order the party who caused all the trouble to pay the legal costs for dragging everyone to court in the first place.
So, when you boil it all down, the big takeaway is this. The motion to compel, with all its strict forms and deadlines, isn't just about bureaucracy. It's the engine that makes sure the discovery process actually works. It's how we make sure everyone plays fair and that the wheels of justice don't get ground to a halt by someone trying to obstruct the process.
It really makes you think, doesn't it? The whole process is very rigid, the forms are mandatory, the deadlines are tight. But maybe that strictness is exactly what's needed to guarantee that everyone gets a fair shot. It's something to think about. Thanks for tuning in.